Hi, welcome to My Court Coach. I'm Jalen and I'm going to be your instructor as we navigate through Form DV-110 Temporary Restraining Order. Now, this is a form that the court signs off on if they do in fact grant you your request for a domestic violence restraining order. So just because you complete this form doesn't mean that the court is going to automatically issue your restraining order. You need to prepare it as part of your domestic violence restraining order packet so that the court can easily review what you are requesting, because it will mirror your order, your temporary emergency order. And all the judge has to do is check off some boxes and sign his or her name at the end. So you want to provide this as a courtesy, and it is required to have the temporary restraining order completed at the time of filing. So essentially you're providing a proposed temporary restraining order. So the court will require you to fill out your name, and if you have a lawyer, your lawyer's information is going to be listed on here, the name of the other party, the description of the other party, so whether they're male or female, their height, their weight, their hair color, their eye color, their race, their age, their date of birth, if you know their address, and what's their relationship to you. So it could be your father, it could be your significant other, your ex-boyfriend, your ex-girlfriend, your mother, your brother, somebody that has some sort of relationship to you. Even a mother-in-law would be appropriate. And you have to fill this out to the best of your ability, and this information should mirror the information that's on your request for a domestic violence restraining order, because it does ask for the same exact information on there. So additional protected persons, those who are also will be listed on your request for domestic violence restraining order, and you will include their name, relationship, and sex and age. If you need additional space, you can always use MC025 and include their information on that by just stating that they need to include additional protected parties, and you can say that this is DV-110. And then this section is going to be completed by the judge, and the temporary restraining order is going to expire at the date of your hearing. So you're going to have the hearing date and the time, of course, and then the location is going to be what's written here. And so the court wants to ensure that you will in fact be protected up until the hearing, and then you both are going to argue why this restraining order should be more than just a temporary restraining order, or the other party will argue the exact opposite of that. So the court will complete the rest of this form, and the court is notifying you and the other party that this is in fact a court order. It's going to complete whether there is a criminal protective order. They're going to obtain that information based off of what you had written in your request for a domestic violence restraining order, whether you're aware of any restraining orders between you and the other party. And if no information has been provided, then the court's just going to go ahead and check off that box. And then the court is going to check off any one of these boxes: not requested, denied, or granted. It notifies the other party that the court has granted the temporary orders checked below. If you do not obey them, you can be arrested and charged with a crime. You may be sent to jail for up to 1 year, pay a fine of up to $1,000, or both. So very serious consequences if somebody does violate the temporary restraining orders. So typically, we would actually just check off all of this and fill out that it's like 100 yards or 1 yard, or if there's a different address, we would go ahead and locate that, because all we really want the judge to be doing is just checking off these boxes. That's it. We do the rest. So if you're asking that the parties refrain from harassing you, attacking you, striking you, check this box off. You don't want them to contact you, check off this box. To take any action to obtain your address or location, you're going to go ahead and check off this box. If you have any kids together, but there is supervised visitation that's being requested, or some sort of visitation schedule that's being requested, then you can go ahead and do exceptions, brief and peaceful contact with the person. If they're, and same goes with the stay away order. The move out order is the same. You'd need to add in the address so that the court can go ahead and grant it or deny it. No guns or firearms. So if the court has received information about you owning firearms, then they have to return the firearms within 24 hours. And then within 48 hours of them receiving this order, they have to file with the court a receipt that proves that the guns have been turned in. Recording unlawful communications, the court will also check off one of these boxes. Same goes for the care of animals, the child custody and visitation, the child support, not ordered now, but maybe ordered after a noticed hearing, property controls. So this is different than the move out order. But like a vehicle can be included in here. And if you did request a vehicle control and possession, then you should include that here. The debt payment, that could be denied or granted. Most of the time it is not granted on a temporary basis unless you show some really good reason why you need it. Property restraint, if you're married, this is more or less automatic. The court will grant this to you guys. Spouse support, it's not going to be ordered now, but it can if you file a noticed hearing. A noticed hearing is a request for order. Right to mobile device and wireless phone account, the court can go ahead and deny it, grant it. You have to fill out the mobile device and the account number. The judge is not going to fill that out for you. You need to fill it out, otherwise the court will deny it. Debt payment, same thing. You write the wireless provider, the amount, due date, and this all should mirror your request for a domestic violence restraining order. You can't have two different types of information on there versus what you would have on here. And then transferring the wireless account, the court's not going to order that on a temporary basis, but they can if you file a request for order. And then insurance, the court is going to check off these boxes, especially if you guys are married. Lawyers' fees and costs, again, it's not going to be ordered on a temporary basis, but can after you file a motion for it. Payment for costs and services, and the batterer intervention program, those three must be filed at a later date after your restraining order hearing. And then any other orders. So if you requested any other orders as part of your restraining order, then you need to list those exact items also here so that the court can grant it, deny it, or not requested. So we want to make this as easy as possible for the court, because all the court's doing is checking off boxes and signing his or her name right here and dating it. There is no fee for the service of this form. So it says if the sheriff serves it, then he or she will do so for free. So this is only with the sheriff. So if you have you hire a process server to do it, then of course you're going to have to pay that fee. And if you prevail on your restraining order, you could always get those fees reimbursed, or some parts of those fees reimbursed if you win on your restraining order ultimately. So it also warns and notices the person in two, which is the alleged abuser, what will happen if they don't obey this order. They can be arrested, charged with a crime. They can go to jail or pay a fine. It could be considered a felony to hide or take a child in violation of this order. If they travel to another state or tribunal or make the protected person do so with the intention of obeying this order, you can be charged with a federal crime. They can't have guns and or firearms. Service of order by mail. So if the judge makes a restraining order at the hearing, which has the same orders as in this form, you'll get a copy of that order at your last known address, which is written in 2. If this address is incorrect, or to find out if the orders were made permanent, you have to contact the court. Child custody and visitation. If you do not go to the hearing, the judge can make child custody and visitation orders without hearing from you. Same goes for child support. So it has to be based off of the incomes from both parents, so the parents can have the support taken directly from the parent's paycheck. Child support can be a lot of money, and usually you have to pay until the child is 18. You have to file and serve a financial statement or an income expense declaration if you want the judge to have information about your finances. Otherwise, the court may make support orders without hearing from you. Spouse support, you have to file an income expense declaration so the judge will have information on your finances. Otherwise, the court, again, can make support orders without hearing from you. This is instructions for law enforcement, so the order is effective when it actually is made, but it's enforceable by any law enforcement agency that has received the order, is shown a copy of the order, or has verified its existence on the California law enforcement telecommunication system. If the law enforcement agency has not received a proof of service on the restrained person was not present at the court hearing, the agency shall advise the restrained person of the terms and order and then shall enforce it. Violations of this order are subject to criminal penalties. Arrest is required if it is violated. So, if an officer has a probable cause to believe the restraining order had notice of the order and disobeyed it, then the officer must arrest the restrained person. A violation of the order may be violation of this penal code. If the protected person contacts the restrained party, then even if the protected person invites or consents to contact with the restrained party, the order remains in effect and must be enforced. The protected person cannot be arrested for inviting or consenting to contact with the restrained person. The orders can be changed only by another court order. So if you are on the receiving end of this, and the other party is inviting you or contacting you, don't fall for it. And if you are the person that's pursuing a restraining order, it doesn't look good for you in court if you are contacting the other party and yet you're telling the other party that you want them to stay away from you and not contact you or do anything. It goes both ways. So, conflicting orders, priorities for enforcement. So if there's more than one restraining order has been issued protecting the protected person from the restrained person, the orders must be enforced into the following priorities. So if there's an emergency protective order, if one of the orders is an emergency protective order and it's more restrictive than the restraining orders, then it has precedence in enforcement over all orders. If there's a no contact order that is included in a restraining order, then that has precedence in enforcement over any other restraining order. If there's a criminal order and a domestic violence restraining order is issued, then the criminal case takes precedence in enforcement over any conflicting civil court order, and any non-conflicting terms of the civil restraining order will remain in full force and effect. I will say that if you do have a criminal action pending while this temporary restraining order is also in effect, the court will grant you a request to come back to the family law department, so for your domestic violence restraining order, after your criminal case has been resolved. And this is a constitutional protection for self-incrimination. And so you would want to handle your criminal case first before proceeding on the domestic violence restraining order. And if you're not aware whether a criminal case has actually been filed, then you need to contact your local jurisdiction. So if there's more than one family, juvenile, or other civil restraining or protective order has been issued against the restrained party, then the one that was issued last must be enforced. For custody and visitation orders, it's saying that the custody and visitation orders are on DV-110, and they're sometimes also written on additional pages, or other orders that are not part of the restraining order. Those would also be in full force or effect. Forms DV-100 and DV-105 are not orders, so do not enforce them. Now, certificate of compliance with VAWA. This temporary protective order meets all full faith and credit requirements of the Violence Against Women Act upon notice of the restrained party. So this court has jurisdiction or authority over the parties and the subject. The restrained person has been and will be afforded notice and a timely opportunity to be heard as provided by the laws of this jurisdiction or the state. This order is valid and entitled to enforcement in each jurisdiction throughout the 50 states of the United States, District of Columbia, tribal lands, and all U.S. territories, commonwealths, and possessions, and shall be enforced as if it were an order of that jurisdiction. So that informs the other party that this, regardless of where you go within the 50 states, this is enforceable and that you cannot violate this restraining order. And if you do, then you'll have civil and criminal penalties, and it could be a federal crime and all the other warnings that is listed within this temporary restraining order. So the clerk has to date and sign it, and it states that they are certifying that it is true and correct of the original file in the courthouse, and they will seal it, and you will go ahead and submit this to the sheriff's department, and they will serve it on your behalf. I hope that you find this helpful, and good luck.